as you just spoke, we are also here on 2025 CR 130, also captioned State of Kansas versus Aaron Wilbur Dye.
This is weird because as long as he's in high school.
I'm hearing someone's conversation.
It's bleed over from Mr. DeHoyos' office.
You know, one of these days will move me into a proper office and I won't have this problem.
All right. Well, let's see. That is the case, Mr. DeHoyos, as you said, that has all of the offender registration charges, felony level 6, counts 1 to 5, and you said you're going to waive that hearing?
Yeah, Judge, the probable cause on that is readily established, so yeah, we'll waive that.
All right. So, Mr. Dye, can you hear me? You're muted, sir.
Yeah, I can hear you.
Okay. So your attorney tells me on this one case, at least you're going to waive your right to preliminary hearing. Because the court is so advised, I need to go over some things with you on the record to make sure you know what you're giving up. Because you are charged with a felony offense of violation of Offender Registration Act in counts 1 through 5, any one of those felony counts would entitle you to a preliminary hearing. At a preliminary hearing, the state of Kansas has the burden of producing evidence to make it appear that a felony crime has been committed in each case and to show probable cause that you committed that crime in each count. I said each case, I meant each count. A preliminary hearing is not a trial to determine whether you're guilty or not guilty. Rather, it's a hearing to determine if there is enough evidence to require you to stand trial, or in other words, to be bound over for trial. At the preliminary hearing, you have the right to be present with your attorney, as you are now, and you would have the opportunity to challenge the state's evidence, to challenge the existence of the probable cause for further detention or for requiring bail as to each of the felony charges. You would have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. Now, your attorney has probably gone over this with you, but as I said, I have to go over it again on the record to make sure you understand what you're giving up. A preliminary hearing would apprise you about the nature of the crimes charged and the sort of evidence you'd be required to meet if you were to stand trial. But if you waive or give up your right to a preliminary hearing, there will be no preliminary hearing in this case, at least, and you will be bound over to the district judge for further proceedings in this case. You will be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to each of these felony charges, and should there be any misdemeanors, to any additional misdemeanors. I don't believe that there are. And until that time, you will either remain in custody, remanded to the custody of the sheriff, or you'll be allowed to make your appearance bond and be released on that if or when you're able to make your appearance bond. You will continue to be obligated to appear under the terms of the bond. Now, have you had a chance to talk to your attorney about these matters?
Yes, ma'am.
And do you wish to waive your right to preliminary hearing?
Yeah.
Do you enter this without any threats or promises of anyone causing you to waive your preliminary hearing?
Yes, ma'am.
So no one has made threats or promises to cause you to waive this hearing?
No.
Are you in good health today?
Yes.
Are you taking any medications? might impair your judgment today?
No.
Mr. De Hoyos, do you know of any reason why the court should not accept the defendant's waiver?
I don't, Your Honor.
And Ms. Gillett, does the state wish to waive its right to preliminary hearing?
State does, Your Honor.
Very well. The court finds the state of Kansas has waived its right to preliminary hearing. The court further finds that the defendant has made a knowing waiver of his right to a preliminary hearing after consultation with counsel. Therefore, it is the order of the court that the defendant is bound over to the district court judge for further proceedings. And the defendant shall next appear. Missy, when will that be?
Case will go to Judge Crum. And how about set it with the other case that's already in front of him, 11/26 at 9 o'clock?
Any objection to that? That was what day?
November 26th.
Oh, okay. I thought that was a case number. 11/26, 2025 at 9 a.m. before Judge Crum for arraignment. Does that work for everyone, Mr. De Hoya?
Yeah, that shouldn't be a problem, Judge. I've got a couple in Aaron's cases that day too. So
All right. And Ms. Gillett, does that work for the state?
I already have a huge docket with Judge Crum on the 26th. No big deal.
All right. So, Mr. Dye, I trust that will work for you if you could appear for arraignment November 26th at 9.
Yes, ma'am.
All right. That will be by Zoom. So should you bond out, make sure you're back by Zoom on that date and time.
Okay.
All right. Now, you folks mentioned another case Mr. Dye has at that time, but that is not the other one we're here for prelim on. That's not the 102, is it? You haven't already addressed that? Okay. So, Mr. Dye, I'm going to take up with you now your right to a preliminary hearing in case number 2025 CR 102. And that is the case in which you're charged with count 1, distribution of a certain stimulant, methamphetamine. Well, let me pull up your charging docket to make sure I get it absolutely right. Sometimes the summary isn't the same as the actual charging document on here. Okay, in count 1, you have a right to preliminary hearing because you're charged with the level 4 drug felony called unlawful distribution of a certain controlled substance, methamphetamine, in an amount of at least 3.5 grams, but less than 100 grams. In count 2, you're charged with unlawful distribution of drug paraphernalia, to wit, a digital scale and numerous plastic baggies. This is charged as a level 5 drug felony. Count 3, no drug tax stamp affixed to approximately 5 grams of a controlled substance in violation of Kansas law. This is a level 10 non-person felony is charged. Count 4 is charged as aggravated endangering a child, to wit, living in a home, it says, from which methamphetamines was being distributed or possessed with the intent to distribute, a level 9 person felony. Count 5, unlawful possession of the controlled substance, methamphetamine or MDMA, a level 5 drug felony. Count 6 is the misdemeanor. So it is 1 through 5, each the felony that entitles you to preliminary hearing. And I understand we are set for actual evidentiary hearing. Is he wishing to proceed on that as an evidentiary hearing, Mr. Jorge? Or Mr. De Hoyos, sorry.
I've been called worse things this morning, Your Honor. And yeah, we are.
All right, thank you. Ms. Gillett, are you ready to proceed for preliminary hearing?
We are, Your Honor.
Very well. I trust there are no opening statements, or are there? No. All right, then, Ms. Gillett, you may call your first witness.
Your Honor, we call Deputy Blake Fisher. Sure.
Good morning, Deputy Fisher.
Good morning.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You may lower your hand, and Ms. Gillett, you may proceed with questioning.
And could you please state your name for the record?
Deputy Blake D. Fisher
How are you employed?
by the Greenwood County Sheriff's Office.
And how long have you been so employed?
Since December of 2019.
And Deputy, what drew your attention to the residence Mr. Dye resided in?
I was attempting to serve a civil process paper at his residence.
And what happened when you went to serve that civil process paper?
I observed the odor of marijuana coming from within the
Did he just say I observed the odor of marijuana?
residence.
And were you able to then verify that it was coming from that residence and not a different source?
I was.
And what did you do after you noticed the odor of marijuana coming from the residence?
I contacted Sergeant Cordell to have him sit at the residence to secure the residence while I applied for a search warrant.
And were you granted a search warrant for that residence?
I was.
And did you execute that search warrant?
I did.
What was the date that you executed the search warrant?
That had been Thursday, June 12th of 2025.
Who assisted you in the service of the search warrant?
You broke up, Jill.
Who assisted you in the service of the search warrant?
Sergeant Cordell and Deputy Oakley.
And where was Deputy Oakley staged?
Outside the residence.
And what did you and Sergeant Cordell then do?
We entered into the residence and executed the search warrant.
Was there anyone home when you began to execute the search warrant?
Yes.
Who was home?
Leonard Airy and Jeffrey Airy.
Did you end up identifying whose bedrooms were who?
Yes.
And were there items found in other areas of the house besides the bedroom belonging to Mr. Dye and Ms. White?
Yes.
Judge, I'm going to object both to relevance and also lack of foundation.
Well, as to foundation sustained, as to relevance, denied for now.
Now, did you and Sergeant Cordell then begin a search of the bedroom that is Mr. Dye's and Ms. White's?
Judge, I'm going to again object to lack of foundation.
Again, sustained.
I don't know why he's objecting to foundation. I mean, we've already
Well-
established that inside the bedrooms.
Well, maybe you better do a little bit more of that because I don't think so.
Did Mr. Airy claim his bedroom?
He did.
And did you then identify Ms. White and Mr. Dye's bedroom?
I
Judge,
did.
again, again, I object for lack of foundation.
And did the
Judge, I've
juvenile-
objected on lack of foundation. The previous question, you're currently muted, so nobody can hear you answering.
Thank you. Sustained. Ms. Gillett, just ask him how if he found out who had the bedrooms and how.
How did you find out whose bedroom was whose?
Are you serious? The judge is the prosecutor now?
Mr. Airy told me.
And
The judge, I have to
did,
object to that on hearsay grounds.
Well, can you give us?
Judge, we have issued subpoenas for numerous individuals to be here, and some of them aren't here. So I'm going to have to ask for a continuance.
If that's the case, Jill, then why did you even start in the first place, you moron?
Because the juvenile did not show up today that is under subpoena and has not responded. So we'll ask for a continuance for a material witness.
Well, before we get to that, it's not hearsay if he's not offering it solely for the proof of the matter asserted, which it sounds like he is, that the only reason he knows it's the bedroom is because the unavailable witness isn't here to say that, yeah, he told him that. However, does he have any other evidence once he got inside the bedroom as to how he knew that was?
He does. If we get to that
Well,
point, but he keeps objecting to the foundation. So we'll just
well,
get to what's in the
Let's
bedroom.
do that, and let's keep our attitude in check. Go ahead.
items were in the bedroom, deputy?
I didn't hear that question. It cut out. Could you say that again?
Whose clothing items were in that
There
bedroom?
were
Judge,
feminine,
objective lack of foundation as to who.
I just asked him whose clothes he found in the bed, or just to ask him what kind of clothes he found in the bedroom and how, if at all, did he determine who they belonged to? Try that.
Whose clothes?
Sustained.
What kind of clothes did you find in the bedroom, and how did you identify that that was Mr. Dye's and Miss White's?
there were feminine clothing inside the bedroom, and the only female that was residing at the resident was Misty White's. And I know Misty White and Aaron Dye to be in an intimate relationship with one another.
So I'm gonna
Have you
object to
had-
lack of foundation again.
Have you had contact with Mr.
Judge,
Dye?
I've objected to lack of
before?
foundation.
Just ask him how he knows that what he just said.
How do you know that Aaron Dye and Ms. White is in a relationship?
No, Judge, that's not my objection. My objection is that
I know what
he's
your
saying is,
objection is sustained. I'm just trying to help her establish the foundation so we can move along, Mr. Hoya, De Hoya. Maybe that's not appropriate, but just to try to get us to move along. Your objections are so noted.
I can't ask one question without him objecting, even when they are not objectable.
Not objectable. Give me a break, dude.
Well, so far I find they have been objectable and that there are other ways to ask these questions.
Deputy, what kind of clothing did you find in the bedroom?
Feminine,
Did you find male clothing in that same bedroom?
I did.
And did you find items that would have been identified to belong to Mr. Dye and Ms. White?
I don't recall seeing any like identifications or anything with their proper names on it. No.
Now, did Mr. Leonard Airy have a bedroom in the house?
He did.
And where was his bedroom in the house?
His was the first bedroom.
Okay.
How do
And
you
you-
know that? How do you know that was his bedroom?
Can I ask the next? How do
Well,
you
I
know that
think
that
we
is
both
his
knew the
his
objection.
bedroom?
Ms. Gillette, stop. I think we both knew what objection was coming. Again, I was trying to help you, Ms. Gillette, get around that.
How do
keep
you
us
know
moving.
Mr. Leonard Airy's bedroom was the front bedroom?
He told me.
again, objection to hearsay.
Not for the proof of the matter, but to establish whose bedrooms.
Is that not a matter that you're trying to prove?
Judge, if he claimed his bedroom and it is the front bedroom, then it's establishing the layout of the house and where everyone was. Was Mr.
You need to have this officer just tell you how he knew where people lived in this house. If he made that conclusion, he had to have a reason for it.
If those are words by a party who's not here, it's all hearsay, and I have to object at length to
Admissible.
it.
It is admissible, yes.
And Deputy, how did you know where the juvenile's bedroom was?
I located the juvenile down in his bedroom.
And
Is that the
where is
juvenile that's not available for questioning, Ms. Gillette?
he's under subpoena. He didn't show up. And he also told us that that was Leonard Airy's front bedroom and that his mom and pseudo stepdad lived in the second bedroom. And he is under subpoena and did not show up today. So we can ask for continuance and go get him from the school.
Other than inadmissible hearsay, do you have any way this officer can testify as to whose bedroom was whose? Or
I don't know if Sergeant Cordell found IDs in the bedrooms either.
all right. Well, I'm gonna either have the option of dismissing the case or granting the continuance. How soon can your witness be here? You said something about school?
I believe he's at the school. He's under subpoena, but he should be at school today.
That's
We
here
can
in
check and see
Eureka,
if he's at school.
at Eureka Middle School, high school, middle school.
High school.
All right, I'm going to grant the continuance. How much time do you think you need to get him available, Ms. Gillette?
I don't know. Give me a little bit to call up to the school and see if we can get him.
Well, Mr. De Hoya's, if I take, it's De Hoya, right? I don't pronounce the S.
It's de Oyos, Oyo.
Oh.
But yeah. But Judge, I mean, everyone knows who you're talking to.
Okay. Say it again for me, please. I know I've tried to get
No, it's okay. De Hoyos.
De Hoyos. Okay, Mr. De Hoyos. You'll work with me on that every time. If I grant, how about until 9:45? Is that going to work with your docket? I know you probably have other things today.
Judge, I'm in front of you at 10, so you tell
Okay,
me.
then it works. I'll let you be late for the 10 o'clock. Okay, Miss Gillett, please call the school or whatever you need to do to
Now,
get.
Judge, Jill.
Oh, I should have checked with you, Mr. Deputy Fisher, too.
No, it's fine. I just want to make it clear that we're gonna need both Jeffrey and Leonard.
Okay, you don't think you can establish the question?
Leonard was the one who told me. I just am trying to avoid any more hearsay objections. I knew it was gonna happen. I'm just trying to, we're gonna need both Jeffrey and Leonard.
No, okay. So who are they? Are they the children that were in the home?
One's a child, one's the brother.
I can establish the bedroom ownership for the bedroom in question.
All right, Ms. Gillett, I don't want us all taking over your case. I know you want to present your own case, and you should. So how do you want to proceed with all these suggestions thrown at you here?
Well, Judge, I will have to call Sergeant Cordell, but I'm in the middle of questioning Deputy Fisher. So I can either take a break from questioning Deputy Fisher and switch over to Sergeant Cordell. And the child no longer goes to school here. His mom has moved him to a different school. So
we just need to move this to a totally different date? Or can you make it work with Sergeant Cordell and Deputy Fisher?
Your Honor, I don't have an objection to having Sergeant Cordell attempt to lay down the appropriate foundation. I will object in the same way that I'm doing to Deputy Fisher, and it's not disrespect to either one of them. It's just doing my job. But I have no problem taking a pause, let Officer Cordell see if he can establish such. If he can, then I'll stop my objections. But if he can't, again, we may have to continue this.
Sergeant Cordell, can you answer the questions that have been answered so far without having to rely on other people?
Hold on a second, Judge.
I'm getting too involved in this. I'm getting too involved. I apologize. All right, Ms. Gillett, your case. Tell me how you want to proceed. Do you want to continue it to another date? Do you want to continue this until 9:45? What do you want to do?
I don't know that we'll get it done if we start back up at 9:45 in time for the 10 o'clock.
You said you have the 10 o'clock, Mr. De Hoyos?
Yep,
Judge,
we do.
Yeah, Judge, if it means anything, I think at this point, I just prefer another date. There's nothing against anybody here. It's just that I think we've got a 40 or 45-minute prelim right now, and we're going to push well past 10 into 10:30, and then your schedule and my schedule is gone.
Okay, so Ms. Gillett, are you asking for a continuance?
Yes.
To another day?
We had witness that is a material witness did not show up.
All right. Now, those material witnesses, are they in state's custody? So the state's responsible for not getting those boys here?
No. Well, he's in DCF custody.
And he was served a subpoena to be here today, and he's a minor, correct?
Yes.
All right, so you might want to chat with your colleagues at DCF about not honoring an order to be here. And so you can't get him here, the young man. And the other one you said is an adult brother of the defendant that just chose apparently not to come?
I don't know if a subpoena was issued for him or not, but there was one issued for the juvenile. So
I also don't think the two are related insofar as the defendant and the other gentleman.
Well, didn't I hear the word Leonard and brother?
He's the brother of Ms. White, and he was the roommate of Mr. Dye.
Okay, and Miss White is the one that he's allegedly that the defendant is allegedly in some kind of relationship with?
Yes.
Okay. But he is an adult. All right, first order of a business will be, I will grant the state's request for continuance to another day to get all of her witnesses lined up. Missy, when can you give us a new date for preliminary hearing? I don't generally like to bifurcate preliminary hearings, but we haven't gotten enough into this one that, and Mr. De Hoya, you're not objecting?
Judge, I'll put in a form objection insofar as that today was the day called for it, but no, I'm not intensely trying to stop anything here.
Okay, so over defendants reject objection. Granted to what date? Missy? And are we thinking, how much time are we thinking next time?
This is an hour tops, if that.
Okay,
I have 9 o'clock on November 14th available.
I don't.
I'll strike that then.
I have November 18th. I have 9 or 10.
I can make either of those work just fine.
Okay, let's go November 18th, 10 a.m. Or Deputy Fisher, do you have a preference? I don't know if you're working nights or mornings. Do you have a preference on 9 or 10 on the 18th? Are you available?
Of November.
Yes, you did say November.
Mhm.
I'm scheduled to work that day at 3 in the afternoon, but I'm sure I can make it work if we have to.
Thank you,
Sergeant
officer.
Cordell, are you the one that assigns his schedule?
I am not. He's on a regular rotating schedule.
Okay, what's that gonna do to your schedule and his, Sergeant Cordell, if I move this to 10 a.m. November 18th?
I will be available.
And will he have enough time to sleep, or is that up to him?
I'll have enough time, Judge.
Okay. I
Judge,
know Deputy Fisher's always accommodating, but I would like to take his humanity into consideration too.
Appreciate it.
And Judge, before we get off the record on this matter, I do want to move for bond on his 3 cases.
All right, well, and Sergeant Cordell, that works for you too, that November 18th at 9 or 10?
Yes, ma'am.
Okay. Sergeant or Deputy Fisher, do you have a preference for 9 or 10?
10 would be preferred if we could.
All right, if there's no objection, this is continued at the state's request for preliminary hearing to 10 a.m. November 18th by Zoom. Okay, now then, you said that you had a defense motion for what?
For bond, Your Honor, on his 3 cases, on Mr. Dye's 3 cases. And this, to state's fairness, I had maybe approached this, but I don't think I ever officially informed them we were moving for bond. So if they call it for waiver or notice, then that's appropriate.
Okay, Ms. Gillett, do you have any objection to proceeding with motion for modification of bond on 3 cases?
We've argued this at a lot of his hearings. Mr. Dye has a revocation pending in front of Judge Crum. He had the offender registration issues, which are a presumptive prison case. And this current case, which is 25 CR 102, he has also has the issue of having his taking off from the scene, and he was basically AWOL for over around 30 days-ish. He wasn't arrested until about 30 days later on this matter, and he had offender registration issues continuing throughout that time as well, and didn't come in to register and was essentially on the run. Now, he did eventually turn himself in because he was tired of running, but he has 3 cases pending. The bond on this case is $40,000 cash or professional surety. He has a different bond on the offender registration case, and he has the revocation matter that is set before Judge Crum, which we do not have jurisdiction over, changing the bond in that matter. So we can't hear the bond on the revocation matter today, only the bond on this matter, there's a 102 and the 25 CR 130 that he waived preliminary hearing on. And he committed both of these crimes while on community corrections.
Yeah, when I call up his Odyssey criminal history, aside from some civil matters, I start in on the criminal, the 2025 CR 130 that I have, that he waived on, the registration charges. He has the 25 CR 102 that we were trying to do preliminary hearing on today. And the bond on that has not been made. Then I see that 20 GW 22 CR 48. That's the one you say he has pending revocation before Judge Hart
Brown.
or Judge Crum 1017. Is that right? From what I'm looking at here. He has some kind of cloud supervision or sentence pending. Is that right?
I wasn't aware of that one. Let me check.
Let me see if I'm reading that right, because they've got it thrown in there under 22 CR 48. That may just be part of this one we've just talked about. Yeah, I think that's this third case with Judge Crum. There's quite a few activities on there. Most of them, I think, are civil, though. Not all. All right, anything further you want to say, Mr. De Hoyos?
So, Judge, in these matters, Jill's recitation of your jurisdiction in this matter is absolutely right. We can't touch the PV case right now, but these first two, Mr. Dye is here, he's appeared. If you go pull his criminal history, you'll see that he doesn't have any person felonies. He's an E-box. It's kind of weird, right? Because I've got his file in front of me. I've got the most recent PSI, that 22 case. He's E-box. I mean, his issue is he's a drug user. That's his issue. And it's only in the recent change in law with regard to aggravated endangering a child that charge is even allowed to be brought in this circumstances. And that being that a child is in a home where a lot of meth is found, right? So it's important to note that there is no intentional violence from Mr. Dye in his history. There is a drug addiction. That's what he has. That being said, Judge, Mr. Dye has a home, a housing opportunity literally across the street from the county courthouse. His parents live right there. He's able-bodied, he can work. I mean, ultimately what that guy needs to do is sober up and get control of his addiction. But I don't believe the court needs to be afraid of this man. I mean, he is not violent despite his lengthy criminal history. He has no history of harming another human being in his lifetime. So, Judge, the other thing I take issue with on one of the things that Jill said was the argument that Mr. Dye fled the scene. That's not the case. He wasn't at the scene. And then about a month later, he turned himself in. On July 12th, the deputies entered his home, and on July 14th, June 12th, and then July 14th, he turned himself in. So I think that's a sign that he will comply with your request for him to appear in court. I think he's probably gained a little bit more confidence in me in witnessing our exchanges today. So I trust that he'll take my word when I tell him he will be there and we'll do our jobs. For that reason, Judge, I'd actually consider an owner cognizance bond on these two cases, but in the event the court still wants to put a bondsperson on these cases, and ask for a bond of $5,000 on each case. I mean, at the end of the day, this man has got a publicly appointed attorney because he doesn't have a penny to his name. So finding some amount that's reasonable is going to look low because that's what's necessary to make things reasonable. So all that being said, Judge, I'm asking you to consider a owner cognizance bond on both these matters, or in the alternative to reduce the bond in both cases to $5,000.
I thought he was homeless. How long has he had this address at his parents' house across from the courthouse?
Mr. Dye can answer that question better, but I believe his parents have been living there quite some time.
Well, I'm not concerned about his parents directly. How long have you claimed your parents' address, sir?
I haven't claimed, that's where I would stay if I got bonded out. Because I have no contact with my co-defendant, so I can't go home. I'm actually buying a house at the address where this happened, 211 South Elm. I'm actually renting to own the house, but I can't go there because that's where my co-defendant's staying. So my parents live just right across the street, though. I can go there.
Do they live in the apartments or do they have a
Yes.
house across
They
from
live in the
court?
apartments.
And they've been there how long? I said I wasn't interested in them, but I guess I just haven't.
Almost 2 years now.
They've been there 2 years. Do they work? Are
ma'am.
they retired?
They're on disability.
Okay. And what were you doing before this case came about? You were living with your romantic partner and her sons in a house?
Yes, ma'am.
And is that the house you said you own?
I'm renting to own.
Renting to own. And
Yes.
now, and I'm somewhat familiar with her situation. So now she's renting to own and you're out, or what's going on?
Yeah, well, I mean, until all this is resolved, yeah, we're both on the lease.
Okay.
So
And who's making the payments? Is she or you? Or both?
she is at time. I'm in here, of course. So
Okay. Have you been out in custody since the original arrest?
no, ma'am.
So that's been what, since about July?
Yes, ma'am. When I turn myself in.
You turned yourself in on a warrant for your arrest. Is that right?
Yes, ma'am.
Mm-hmm. Have you been able to get in?
During the warrant,
Yeah.
during the search warrant, Miss White pulled into 303 South High Street in Eureka, private property. She didn't have permission to be there. She pulled in there and let Mr. Dye go. So before she returned back to the house.
So I've heard her preliminary hearing, correct?
Yes, she also claimed that she was not living with anyone at that residence other than her son during her first appearance, and claimed that she didn't live with Mr. Dye or that he didn't live there. And she also claimed that only her and her son lived there and left out her brother, which then admitted to living with his sister. And then Mr. Dye, at his first appearance, admitted to living in the house with her. So most of all the statements between the three of them don't match.
I can't change whether or not other people lie, but Mr. Dye hasn't told us anything that's not true so far.
Well, you're not offering yourself as his witness, are you, Mr. De Hoyos?
No, Judge, I'm not.
Okay, you're going by what he's told you.
Correct, Your Honor.
All right, okay. Mr. Dye, I'm sorry, maybe I've already asked you this, but what do you do for a job when you're not in jail?
I was working for Southeast Kansas Independent Living. I was my mom's care worker, her direct service worker through them.
Okay, so they paid you.
It's home health care.
Yeah, they paid you to live with her and be her attendant rather than having to hire a nurse and so forth.
Well, I didn't live with her. No.
Oh, you just came in and checked on her, or what'd you do?
Yeah, I came to their apartment and took care of her. And I had so many hours a week that I would have to go over and
make sure she took her medicine, make sure she got to
yes.
appointments, things like that.
Yes, ma'am.
Okay. And you did that for how long?
I did that for a little over 4 years, actually.
Where did you live before you started doing that?
When I started doing that, I lived in Winfield.
And what'd you do in Winfield for work?
Same thing. I was home health care worker for 4 years.
Okay, so that's your career. Your adult career is home health.
No, before that, I've worked in oil field, construction.
Okay. Who did you provide home health care to in Winfield? Was that a family member?
My mom.
Oh, she used to live there. Then she came here. Why'd she come to Greenwood?
Yes, ma'am. I was in jail and they moved up here.
Oh, okay. So they moved up here to be close to you while you were in jail.
Yes, ma'am. And then
was that since this case started?
No. Like I said, they've lived in the apartments almost 2 years now.
Oh, but you have other cases pending. Okay, so I'm with you. Mr. Dye, with your parents being disabled and in need of care, I am not comfortable finding that would assure your likelihood to reattend future hearings and that would keep the society safe. The types of charges you're looking at here present a good probability of threat to the community by dealing drugs and possessing drugs around children and like, you know, you were in jail, your parents came up here so you could help take care of them, apparently. Then you ended up living with this lady, according to whoever's testimony I buy at the time or believe at the time. Because as Ms. Gillett pointed out, we've had several versions of who was really living where. I'm going to leave your bond as is at this time in the cases that I have, and then you can take your other matter up with Judge Hart. But the very nature of those charges and the failure to register suggests that you don't always comply with court orders. You know, those are just allegations at this time. They also suggest you're a violent offender, because as a violent offender, you are required to register, and it's alleged that you violated that order 5 different times. So I am going to deny your request for bond modification at this time on the 2 cases I have.
Hey, Judge, I'd be remiss if I didn't make mention that he's not registering for violence. He's registering for drug distribution.
Okay, well, the charge says violence, so maybe...
No, it's drug distribution.
Let me double check that. All right, once again, the summary says Violent Offender Registration Act. So let me look at the charging document. I've been having lately the Odyssey summary not comporting with the penalties in the actual charging document. Charging document
has the subsections wrong in the computer system, Judge.
And Jill, if we need to amend the complaint to fix that, just let me know.
No, the complaint is normal. It's the computer system when you go to pick the right charge for the right whatever. Not all the subs are in the computer. You can't find distribution of methamphetamine in level 2, but the exact same subsections also apply to heroin. So it always says heroin because OJ's never fixed it. I literally messaged Pika to get things put in right.
Well, these are charged under subsection A, C, 1A.
Mm-hmm.
And the charges say level non-6-person non-felony, which that must be an error because let's face it, if it's a non-felony, it's a misdemeanor or traffic violation. So while you're amending your paperwork, you might want to address the penalty sections listed there too. I think that's just a typo, non-felony, but it's repeated in all 5 charges.
Felony, I believe we filed an amended on it.
Okay, well, I'm not seeing.
There's an amended complaint filed October 16th of 25.
That was an amended I was looking at, but I don't know if that's the same amendment that you're referring to. Let me call up that 16. Now, on the one filed October 16th, it says the subsection I referenced in the level 6 non-person non-felony. That's the one I was looking at. So it looks like you're going to need another amendment to address a couple of things in there. Because they're not non-felonies. That'd be, like I said, misdemeanor infractions.
Yeah, that just didn't get taken out when they fixed the non-person.
All right.
Yeah,
well,
and I'm not going to object to amendment on that. We knew what it was.
Yeah, I think we all did. Well, we're going to come back here November 18th at 10 a.m. by Zoom, and we're going to try this preliminary hearing all over again. Until then, I'm not going to modify the bonds. When we set this for today, I had a notation in the notes that, all right. On 10/10 of 25, the last time we were here, we set this evidentiary preliminary hearing and said the other one would be for waiver for the felony pleas. I was of the belief that there was a plea agreement or something worked out that would resolve these today. But apparently we didn't get to that. We don't have a plea agreement in these 2 cases or the 3rd case.
Not yet, Judge.
Well, that'll give you a little more time to work on that if you want. So continue to November 18th, 10 a.m. by Zoom, and no modification of bond. And if there's nothing further, we'll be in recess on this case. And in 10 minutes, I'll see you again, counsel. Thank you.
Thank you, Judge.
You're welcome.
Thank you, Jill. Sorry about that.